Good afternoon, everyone, and thanks for joining us today to talk about the world of congressional oversight after conclusion of the McGahn case. My name is Elise Bean, and I'm the director of the Washington office of the Levin Center. Let's see. Oh, should have tried advancing the slide. There we go. We have 4 distinguished panelists with us today, and I want to thank each of them for joining us. I'll introduce them all now, and we'll be following an open format where I'll post questions and any of our panelists can respond. Viewers are also invited to submit questions on the Q&A function. We'll try to answer them as we go, but if we don't, we'll try to reach out to you after the session. So on today's panel, we are honored to have Doug Letter. Doug currently serves as general counsel for the U.S. House of Representatives and represented the House Judiciary Committee in the McGahn litigation. The Office of the General Counsel provides legal advice and representation to not only the House itself, but also members, committees, officers, and employees of the House without regard to political affiliation on matters related to their official duties. Doug joined the House in 2019 after a distinguished career at the U.S. Department of Justice, where he served as director of the Civil Division Appellate Staff, Deputy Associate Attorney General, and Senior Counselor to Attorney General Eric Holder. Doug has argued numerous cases before the U.S. Supreme Court and various federal appellate and district courts, including the McGahn case. Kate Shaw is professor of law at the Benjamin Cardozo School of Law. Her research focuses on executive power, federal courts, election law, and gender issues. Her academic work has appeared in numerous law reviews around the country, and her popular writing has appeared in the New York Times, Washington Post, The Atlantic, and Slate. She's a contributor to ABC News and co-hosts the Supreme Court podcast, Strict Scrutiny. Before joining Cardozo, she served as associate counsel in the Obama White House counsel's office and clerk for Justice John Paul Stevens and for Judge Richard Posner. Reginald Brown is a partner in the Washington, D.C. office of Kirkland and Ellis, where he provides investigations-related guidance, strategic counsel, and crisis management assistance to a broad range of companies and senior executives. He has assisted leading institutions and high-profile clients with more than 100 congressional inquiries. Earlier in his career, he served as special assistant and associate counsel to President George W. Bush. And finally, Michael Stern has served for many years in the House General Counsel's office from 1996 to 2004. He also served as Deputy Staff Director for Investigations for the Senate Committee on Homeland Security and Governmental Affairs, and as Special Counsel to the House Permanent Subcommittee on Intelligence. He writes and comments extensively about congressional legal issues, including on his blog, www.pointoforder.com. He is currently teaching a course on congressional oversight at the George Washington University of Political Management. So, quite a powerhouse panel. Before we welcome our panelists, what I'd like to do is quickly remind viewers of the complicated twists and turns that took place in the McGahn case. So let's start off very simply. The plaintiff was the House of Representatives Committee on the Judiciary, and the defendant was former White House counsel Donald McGahn, who was represented by the U.S. Department of Justice. There were 4 key issues. First, does the Judiciary Committee have a specific injury necessary to bring a case or controversy before the federal courts? Can it enforce its subpoena? Even if they do have a specific injury and standing to sue, do federal courts have jurisdiction to hear an interbranch dispute, a separation of powers issue? Then, even if the committee has standing and the court has jurisdiction, does the committee have a viable cause of action? And once we get past all of those procedural issues, the substantive question is, do current and former senior presidential aides have absolute immunity to congressional subpoenas compelling testimony? So let's get going. The committee files its suit in August 2019. The district court delivers its decision in less than 4 months. In a 120-page decision, then District Court Judge Brown Jackson upholds the subpoena and orders Mr. McGahn to comply. She declines to stay her ruling pending appeal, but the DC Circuit Court of Appeals issues its own stay. 3 months later, the 3-judge panel, and those are Judges Griffith, Henderson, and Rogers, that panel rules 2-1 that the House committee has no standing to bring the lawsuit and the court is without jurisdiction to hear the case, and they dismiss it. In response, upon request, the DC Circuit vacates the panel's judgment and rules that it will hear the case en banc, with all judges participating. 5 months later, the en banc court reverses the appellate panel, finding that the House Judiciary Committee does have standing to bring the lawsuit because it suffered a specific harm, and the court does have jurisdiction to resolve the dispute. And then it remands the case back to the same 3-judge panel. What happens next? We enter into phase 2 when the case has gone back to the 3-judge panel, and the panel considers the matter for less than a month and rules that the House Judiciary Committee lacks a viable cause of action. It never reaches the substantive issue of whether Mr. McGahn is immune to congressional testimony. Instead, it again dismisses the case. This time, the court takes 2 months to decide that, yes, it will again vacate the panel's decision and consider the matter en banc. But then the next month, Joe Biden defeats President Trump in the presidential election. 3 months after that, President Biden takes the oath of office. And in the meantime, the House and the new administration have been requesting a series of postponements in the case. In May 2021, the committee and Biden Department of Justice announced that they've reached an accommodation. It has 4 primary elements. They decide they're going to do a closed-door transcribed interview instead of public testimony at a hearing. The committee agrees it will ask only questions on matters already publicly discussed in the Mueller report. The Biden administration says that it will not assert its executive privilege on those particular matters. And finally, despite having resisted for months, the committee says that the Department of Justice counsel may attend the transcribed interview in addition to Mr. McGahn's private counsel. The interview itself takes place a few weeks later, and the parties then file a joint motion to dismiss the case. In July 2021, nearly 2 years after the suit was filed, the court dismisses the case while also vacating the 3-judge panel's judgment and opinion so that it has no precedential effect. And that brings us to where we are here today. Okay, so I'm going to stop sharing that and invite the panelists to join us.
It's very dramatic.
Thank you so much. And what we're going to do is we're going to start right at the end with the settlement. So the McGahn case was litigated in the courts for 2 years. The district court decision, the 2 appellate panel decisions, the en banc proceedings represent an enormous expenditure of congressional, Justice Department, and judicial resources, all of which ended when Congress and the Biden administration reached a settlement. And Doug, I'd like to go to you first. Can you please describe for us in a little more detail what happened during that settlement process?
Yes, Elise, thank you very much. And thank you for that great summation of what how the litigation went. And by the way, let me just start out by saying I'm appearing here in my personal capacity. I'm not here officially as the general counsel of the House of Representatives, having gotten that out of the way. What happened is, to be honest, we had finally the adults in the room. We got mature experienced people involved in the Judiciary Committee and in the White House who realized that it was in everybody's interest to do what had been done for many, many decades by the executive branch and the legislative branch, instead of making idiotic claims of absolute no, we won't respond to any subpoenas. That, as far as I'm aware, no administration had ever done before, and I hope none ever do since. We had a situation that is much more like what I know Reg and Kate, I'm sure, dealt with in the when they were in the White House, which is you negotiate these things. So once, frankly, the obstructionist Trump attorneys were basically out of the process, we, as I said, these very experienced and mature folks at both the Justice Department, the Biden Justice Department, and the Judiciary Committee were able to reach an accommodation where each side gave and each side got some. And therefore, I think we reached what was a terrific settlement and a victory for the nation, because we had returned to a system where the executive branch and the legislative branch disagree with each other, but they work it out. And sometimes it takes a while, but they work it out. So we got Mr. McGahn to come in and testify right away. There was no more litigation, no more delay. I could have kept litigating this case for years and enjoyed it immensely. You know, another in-bank DC Circuit argument, et cetera. Boy, would that that been fun. But that wasn't the goal. We got Mr. McGahn in. No claims of executive privilege were made. We got his testimony. The Judiciary Committee got what it wanted from him within the boundaries that had been negotiated. And so, as far as I'm concerned, everybody except Trump won. And that is exactly how it was supposed to work. And last is what we ended up with from all that litigation was a major victory for Congress, because we got an in-bank DC Circuit holding that the Congress has Article 3 standing to sue. We got an immediate in-bank grant when the panel, I think, in a very, very poorly reasoned decision, said, there's no cause of action, et cetera. The DC Circuit made quite clear that it was going to reverse that lickety split. It didn't have to, though, because we settled. And we got another district court judge, a highly respected one, who's now on the DC Circuit, joining the other Judge Jackson and Judge Bates, who had all vehemently rejected the absolute immunity kind of claims that were being made. So I assume from now on, any president, a mature president who knows the U.S. Constitution, faced with all of those rulings from judges that really matter in the DC Circuit, they will know that you can't take that kind of absolute stand. Instead, you negotiate and you work it out. And we can go back to what the two branches had been doing for many decades. And we never had the situation of the Supreme Court stepping in. Obviously, a lot of the armchair commentators missed this part. If we had won a resounding victory in the DC Circuit, everybody has to understand, what would the Supreme Court have done with that? We didn't have to engage the Supreme Court. We got to the right result. Again, as I started with, Elise, when we got mature adults in the room.
I'd like to open this up to our other panelists to get their opinions. Perhaps, Mike, you'd like to go first, since I know you've written an opinion upon this, that you felt it wasn't quite as positive a result.
Yes, I am one of the armchair commentators. I would say there are three aspects of the settlement that I think one can point to, and they come out somewhat differently. So Doug mentioned that the information that they got from McGahn, obviously that was part of the settlement. They got whatever they got. And I think, it's up to basically the Judiciary Committee thought that what he was giving them was what they needed at the time. I'm not sure I want to second guess that, I will note, though, that I'm not aware of anything coming out of that deposition that expanded much on what McGahn had already said in the special counsel report. The second issue is on the legal questions that were resolved and not resolved during the litigation. And I agree with Doug that Congress did get a major victory in getting the DC Circuit to accept the fact that constitutionally Congress can have standing to enforce subpoena. But that only gets you so far because of the issue that was unresolved, which is whether they have statutory authorization to bring such suits. And I'm afraid, my understanding is that the Biden administration, like previous administrations, is going to take the position that no such statutory authorization exists. And therefore, you're going to have the same problem next time you want to go to court. And then the final issue, which the one that bothered me the most, was the institutional precedent of allowing the Justice Department to come in to basically attend McGahn's deposition as if he were their client almost, and to instruct him not to answer questions on the basis of executive privilege. I find that institutionally troubling because to me, the congressional position should be McGahn is a private citizen. He has to comply with his legal obligations like every other private citizen. He can, if his lawyer wants to consult with the Justice Department or whoever and use that information to make objections, that's fine, but it's his legal obligation. He's not just a pass-through. The problem with the government's position in McGahn and other cases like this is that they treat these witnesses as if they're just basically stand empty vessels that can be filled up with whatever some OLC lawyer thinks is the proper reading of executive privilege. And I don't think that's the right frame for this issue.
Thank you. Reg?
Yeah, look, I think everybody lost except the lawyers who got to spend lots of time, some of whom I guess were paid, others of whom probably were not. I do agree that Michael has the right view that the issue of a cause of action to sue is still unresolved, and in fact, the Biden administration lawyers, when the matter was vacated, insisted that the 3-judge panel decision was correct. So they've kind of held on to a longstanding executive branch view there, as opposed to moving on that issue. On the issue of whether or not the Justice Department should have been able to attend, in my mind, the privilege is held by the current president, at least in the first instance, and it could only be asserted by the Justice Department. It couldn't be asserted by McGahn because he was a private citizen. I think he had to honor it because it related to conduct that took place while he was in the government, and I don't think that that's a terribly novel position. It's frankly the way we think about attorney-client privilege, which continues on even after the client and the attorney may have parted ways. And so I don't know that there was any other mechanism for the privilege to continue. The Justice Department could have waived it, and that would raise some other interesting questions, which we'll probably get to later. But it didn't strike me that that was a remarkable thing. I will say that we have to think as well about the interests of the executive branch. It's true that this was probably, on balance, a slightly better outcome for Congress than the executive branch, but we should think about the ability of presidents to get kind of unfettered advice from their most senior advisors. This isn't a perfect case for that because McGahn already spoke to Mueller, and so that bridge had been crossed. But I do think that these kinds of disputes, weaken the ability of presidents to get good advice from lawyers who are also in the government.
And Kate?
Sure, I won't add a ton to what my co-panelists have said. I guess, can I just quickly ask a question of clarification, which is that Michael said well, I couldn't tell if you were suggesting, did executive branch lawyers actually raise any privilege-based objections to any answers that McGahn might have given? I thought that they hadn't. Okay, I just wanted to make sure that I was right about that. So, I guess I'll just say, I mean, I am a little concerned about too enthusiastic or celebratory a reaction to a settlement that seems to rest, I guess, on the good faith of the adults in the room. And the happenstance of a non-obstructionist team occupying the executive branch or the White House and DOJ positions of relevance here. So it does seem to me that, kind of implicit in the description that we started with was, things might have broken very differently, and certainly would have broken very differently had it not been the case that adults were finally in the room. And I just don't know how comfortable we should all be about embracing a future of kind of resolution of these disputes that turns so significantly on the kind of good faith of the participants, I think, on both sides. And so I view this as a much more mixed result. And I think that the fact that the timeline that, even if Congress felt pretty good about, or the committee felt pretty good about what it was able to get, I mean, I think I share some of Michael's skepticism that, there was much, if anything, not already covered in the Mueller report that emerged. The fact of an interview, I agree, is relevant, but that so little, in my understanding, new emerged, I think is reason to be a little hesitant to suggest that this was as unqualified a victory for Congress or the committee as I thought maybe the opening note might have struck. So I presume we'll get here later in the conversation, but sort of structural changes that would allow us to enter into future such disputes less reliant on the good faith of the participants, I think would be welcome.
Lisa, I just wanted to say one very quick thing in reaction to actually the comments from all three. We did get a very big thing, which is, remember that McGahn had, as Reg pointed out, McGahn had, with Trump's not just authorization, urging, had already spilled the beans to Mueller, and then that was all in the Mueller report. Remember, that was all there already. Then Trump said publicly McGahn lied, and what we got was, in the Judiciary Committee, we got McGahn saying, because otherwise, he would never have testified. McGahn said, I didn't lie. The Mueller report is right, and what I said is correct. And that's a very big thing, because, that's to say, otherwise that might never have come out.
Let me ask all of you this just quickly. Between the McGahn en banc decision and the Supreme Court decision in Mazars, is it now crystal clear that the federal courts have jurisdiction to resolve an interbranch subpoena dispute? Maybe we can just go to all four and see, do you think that's true? And if it is true, does that at least take one issue off the table? And Doug, I'm going to start with you again.
Thank you, Elise. Well, we know the DC Circuit en banc says there is Article 3 jurisdiction. We're fully aware of that. We know in Mazars, which, remember, that was Trump suing his accountants and his bankers. In fact, in the initial case, Trump also sued the House committee involved. We communicated immediately with Trump's lawyers, said, you can't do that, read the Constitution. There's something called the speech or debate immunity. And they agreed with us and said, oh yeah, and they dismissed us. And we agreed that we would intervene and come in, and the case would be litigated. And then, as you know, the Supreme Court addressed it on the merits. It said it made up a new test that would apply in the future for personal information of the president. And so it clearly was indicated it was remanding then for the lower courts to decide that. So yes, we know that that at least in the Mazars context, it's going to be decided on the merits if necessary. And we know that in the DC Circuit, there is Article 3 standing. And I assume in the future, as I say, any president is going to be very well aware that the DC Circuit very quickly granted a second en banc after Judge Griffith's, it seems to me, very, very clearly mistaken ruling. So no president in the future is going to think, oh, I can just get away with this and drag this out forever. And again, to me, that means presidents, I hope, will instead behave responsibly, and the presidents and Congress will negotiate with each side making compromises.
Anyone else?
I think Doug is right. I do think that there's still a question of a cause of action to sue, at least on the House side. And maybe that'll be addressed through legislation, maybe not. So I would agree with the premise. I worry about the consequences. I think it may push presidents further away from their lawyers. And that could have negative consequences because of fear that what they say to their lawyers, may be public sooner rather than later.
Maybe for the remaining two panelists, we could talk about the fact that they never resolved the viable cause of action issue. Does that in some way kind of nullify the victory on standing and jurisdiction?
Well, I don't know that it nullifies it, but it certainly, it's an additional hurdle that they're going to have to cross. And so unless Congress passes a new statute that authorizes congressional subpoena enforcement actions against the executive branch, this issue is still out there, and there's no authority other than a vacated DC Circuit panel decision that said there is no such authority to control. So I think that's going to continue to be an issue. And although perhaps the administration won't raise standing anymore in the DC Circuit, if it ever gets to the Supreme Court, I suspect that they would raise it. And indeed, since it's not waivable, it's an issue that the court might ask them to address even if they didn't raise it. So I think these continue to be a problem.
Yeah, I mean, I think that the sort of cause of action question remains open. And in some ways, the kind of active congressional debate about creating a statutory cause of action is the sort of thing that I can see courts pointing to if that's not ultimately successful as evidence that in the absence of such positive enactment, no such cause of action exists. And I don't, Mazars is obviously a different posture because it's not a committee coming into the court to enforce its own subpoena. So I don't know I don't feel like I have a great handle on this, on how the Supreme Court would ultimately resolve the question. Although even if you felt confident that in the DC Circuit, the issue is, the signs were all there that the DC Circuit was going to find that the cause of action existed. I'm not sure that we have any sign one way or another from the Supreme Court.
There were a fair number of judges that were recused in that case because I think they had been appointed while McGahn was in the administration. And then I want to believe that maybe Judge Brown did not participate.
Was it Rao and Katsas were both recused? Is that right?
Yes,
Rao
they
and
both
Katsas,
worked.
and then I think perhaps there was one other judge that didn't participate. Was Judge Brown elevated during the course for the last set? Okay, so then there are two judges that did not participate, and who knows what the composition of the court will look like going forward if these issues kind of come up again. I will go back and read the tortured history because I thought there might have been one other that wasn't participating.
And if I, I think the comments from my three panel member brethren are exactly right. And I would pose the question: if you were the lawyers for the House, would you have wanted these issues to be to go to the Supreme Court, Kate? Would you have wanted that to happen? I see Reg shaking his head no. I suspect Michael would give the same reaction. So again,
I mean, it would, look, it would, yes, I hear you sort of, it's better obviously to avoid what could have been a negative result. I mean, it feels to me that as though the background of these disputes, this is sort of just a broader point, it would, a really favorable to a committee decision from the United States Supreme Court would obviously be something that would structure the sort of backdrop against which these disputes unfolded for generations. And so, the kind of like the upside there is substantial. And if you view, as I do a lot of these, ultimate resolutions as at best mixed for Congress after the kind of years of delay that ordinarily redound to the benefit of the executive branch. So there would be significant benefit in a definitive ruling, both on this jurisdictional and on merits, immunity, privilege, other kinds of merits questions. But the downside risk is of course substantial. So I can well see the incentive being to avoid.
Kate, you're not going to make a prediction on how the Supreme Court would have come out on the Article 3 and cause of action and subject matter jurisdiction issue?
Look, I know. I mean, I would hope they would find it not even a hard question. And of course, there's jurisdiction, cause of action. It is almost unthinkable to me that all of a sudden you would remove that the court would be in the position to remove what remains of kind of a meaningful enforcement mechanism that Congress possesses. And so just from the perspective of a meaningful system of checked and separated powers, I would hope that those kinds of pragmatic considerations would figure prominently. But I mean, I'm not sure there's language in the Mazars opinion that was less, cognizant of and solicitous of Congress's legitimate oversight prerogatives. I mean, it recognized them absolutely, but it was more protective of certain, I thought, like sort of loosely grounded presidential equities than I thought it might have been. Particularly if you read it against Vance in certain respects, like Congress having sort of less authority in certain respects than a Manhattan grand jury seemed deeply troubling to me. So I would hope so, but I don't know. I'm not in the business of predicting.
I'll just offer the perspective that Mazars did end up in Congress getting information, and it could have ended up some other way, much more negative. So to me, the Supreme Court essentially reinforced the right of Congress, the duty of Congress to do oversight investigations. So I have a more positive spin on Mazars than perhaps other panelists here. I was so relieved at what happened. I felt like it was a pretty good result, considering all of the worry about what that result might be. Doug mentioned earlier, and I just want to give the other panelists a chance to weigh in, and that's on the issue of absolute immunity. We now have a couple of district courts that have reached that issue. Doug indicated that he thought no president in the future should take that position, but at the same time, we have a Department of Justice, Office of Legal Counsel opinion, which still says that senior presidential aides have absolute immunity. That hasn't been withdrawn. So I just want to ask the panelists, where do you think we are on the issue of absolute immunity for senior presidential aides, former and current?
I think in reality, it's dead. When you really look at these cases, when push comes to shove, there's usually some allegation of possible criminal wrongdoing and the like, and those equities I think tend to weigh in, and you find that immunities aren't asserted or accommodations are reached because people recognize that there are other interests, and so look, if I were the White House counsel, I'd assert it and let a court try to address it, but I don't think I'd have a lot of optimism that I'd win on that concept.
I agree. I think that, first of all, I believe before this case that the absolute immunity argument is borderline frivolous, and certainly every court that has addressed it and has either that has actually ruled on it has said it's clearly wrong, strongly rejected it, and those judges who have not ruled on it have not shown any interest whatsoever in supporting it. So I would hope that the administration might reconsider, but I don't know that I see any evidence that they are going to backtrack from this long-standing. This wasn't something invented by the Trump administration, unfortunately. This is a long-standing executive branch position. Now, if I were in charge of the OLC, which is not going to happen, I would strongly consider revoking my position on absolute immunity and coming up with a new theory based on Mazars, which would give some protection to senior White House aides based on the sort of the heightened scrutiny that Mazars talked about. but wouldn't take this, what I think is a ridiculous position that they just don't have to show up ever, which I think is unsustainable.
Yeah, I mean, I'll just add that I agree that it's a position that, you know, Judge Jackson's district court opinion is like sort of really hard to see any real flaws with the analysis. The Supreme Court, if you're thinking about ahead of what the Supreme Court might have done, you know, reading the tea leaves of both Mazars and the Vance case, like these kinds of absolutist presidential claims, those are obviously distinct claims, but they haven't fared particularly well in the Supreme Court. So I would be concerned if I were a White House or DOJ lawyer that, you know, litigating one of these absolute immunity claims is just like a loser of a proposition, and thus, you know, could actually undermine presidential and executive branch equities, and thus it's just too risky to litigate. And so I think I agree with that figuring out other ways to protect, you know, in the kind of, you know, scalpel rather than kind of sledgehammer way, certain kinds of confidential communications, documents, categories of testimony, things like that, is, you know, both sounder on principle and more likely to be vindicated if, you know, litigation ever reaches the merits. And so I think that's a position. But, you know, given the timeline that so much of this, you know, it's to what I think Reg said, like it's, you know, it's a no cost proposition to just assert it and sort of see where the chips fall. And ultimately the chance of any court actually reaching and, you know, invalidating your position, pretty slim actually. And yet I don't think that's how executive branch lawyers should kind of think about these things at the outset, because A, there is some risk of a court actually reaching the merits, you know, B, I think it can erode other kinds of arguments that get made. And C, you know, they should be making in the first instance what are constitutionally sound and defensible judgments. And if given both what the courts have sent by way of signals and the general kind of principles and purposes that underlie, you know, different kinds of strains of executive privilege, I don't know that they should be making these arguments even in the first instance.
So one of the big complaints about the McGahn case is how long it took. The Congress that filed the complaint was gone before it was resolved, and then it was simply resolved on by a joint dismissal. What do you think the chances are for getting a statutory fix on timing issues, perhaps on cause of action? What do the panelists think about the chances are for Congress actually addressing those issues in the next year or two?
Well, first of all, I just say life after who, you know, McGahn's gone and forgotten by the time the matter was resolved. So you might say that that was a win for the Trump administration in that regard. I think that you need a precipitating controversy to get legislation through. The January 6th insurrection which is being investigated in the House, and the pushback is coming to the House's assertion of authority. That might be a precipitant that could drive legislation forward, at least in the House. You know, whether or not it would survive, you know, in the Senate, I think is an open question. But I wouldn't be surprised to see movement in light of the cases that I think are now beginning to percolate.
Yeah, and at least clearly the House was extremely frustrated by the pace of the litigation. We had certain judges, Judge Maida, for instance, who originally in the Mazars case ruled extremely quickly. You know, he did his job. The other, you know, the pace of the other cases was just, in my mind, unpardonable. I don't understand why that was allowed. Supreme Court said in Eastland that these, when we're dealing with congressional investigations, the court should act very fast. So yes, one possibility is legislation to say the courts must rule on these within a certain number of days, you know, set a very expedited briefing schedule and rule very quickly. And as we know, there are statutes that so provide that in other areas. And I think that, you know, from the House's perspective, I believe the feeling is that would be a very, very good idea. Now, are they enforceable? That's another problem. In general, the courts have said these are hortatory, these kinds of deadlines, but it seems to me it would be very, very good idea for Congress and signed by the president to both houses of Congress to say, courts, this is just no way to act. You need to decide these and within a very short time and pick a time frame. As to the cause of action, remember two problems. One, right now, the Senate specifically has a cause of action, but it doesn't cover executive branch officials. So one question is how useful is it? But two, anything that the House and Senate pass as far as a cause of action, I don't know, is the president going to veto that? Depends on which president, what the president thinks. Is it a president who spent many years in the Senate and thinks that, there should be a cause of action? So that would be something that could be looked at. Our view is we don't need a statutory cause of action. It's just any notion along those lines is just incorrect. And the executive branch doesn't need statutory causes of action. And the Supreme Court precedent so holds. And we don't think that the legislative branch is in any different position from that. So.
Can I just ask sort of a naive question, actually, which is that I wonder whether, given, this sort of hortatory language from the Supreme Court about moving these disputes along quickly and the uneven track record that the federal judges have so far in actually abiding by that, is there any chance of administrative change at the sub-statutory, like at the chief judge of the DC Circuit at the meeting with Howell or Srinivasan, if the executive branch and congressional lawyers were to sort of, talked as an administrative matter to the chief judges of these courts, would there be, it just occurs to me that as an administrative matter, these judges could choose to either formally or informally send messages to the judges to move these disputes along. It's just that it's just wild to me how little that has happened in so many of these really important disputes and how difficult it is to understand why they are. I mean, the census, you guys are still litigating the census case right now, right? And that's been sitting, is that the case before Judge Moss right now? Am I wrong about that? Yeah. So, and I'm not sure, I'm sure the parties are sometimes responsible for the delay, but it seems to me that so much of the delay is on the judge end of things. I wonder if there is just a way short of legislation to get the courts on board with a general, kind of functional separation of powers minded initiative to move these disputes along more expeditiously.
I certainly agree with you. The courts could, send messages to each other, but remember, each district judge has life tenure. Remember, I litigated long enough that I had cases in front of certain judges on the DC Circuit who took, I'm not making this up, 3 and 4 years to issue decisions. District judges who take extremely long periods. As we know, the courts impose on themselves these reporting requirements, et cetera. But you can mandamus, right? At a certain point, the DC Circuit or the Supreme Court could mandamus some judge saying, you must decide within a week. I don't know what happens if the judge doesn't. So I think the answer is yes, they can, and one would hope should send messages. The problem obviously being, I think the DC Circuit was way more dilatory than the district judges have been in the litigation that I've been involved in. So I'm not sure who would be sending the message.
Could I just promote one pet theory of my own? I agree that it would be good to have a statute that's expressly authorizes congressional suits and requires them to be litigated in a timely fashion. But even if you had that, and even assuming the courts would adhere to it, which is debatable, it's still going to take probably longer than most committees are going to have, right? I mean, because you basically have a 2-year window. The dispute has to percolate and ripen, and then you go to court and it can be appealed and go to the Supreme Court. And that's just it's very difficult to see in most circumstances that's going to be resolved in a timely fashion. One thing that I think would help force a quicker resolution of these disputes would be to include in a statute, or even maybe just in the House rule, which is what I proposed, is a requirement that the president himself assert the privilege personally before you get to court, so that you know whether this is a case which the president is actually going to stand behind. Because the president doesn't do that, then I think it becomes a much simpler issue, and there really is no constitutional objection that the courts have to worry about, and it's no longer a question of balancing the interests of the two branches, which is what they're always worried about. So that is my 2 cents for what it's worth.
I'll just add the thought that on the possibility of legislation, there have been a couple of hearings. There's been somewhat of a movement to try to strengthen Article 1 powers from Congress. As Reg said, one precipitating factor may be the January 6th subpoenas that are out there now, but another consideration for the Republicans is, well, maybe they're going to take the majority next. They're going to want to have their subpoenas complied with. And so it may be a moment where they might want to cooperate to say we should have at least some sort of expedited procedure to try to get the courts to resolve.
Of course, at least the flip of that is the possibility that the Republicans are going to take the House back might cause the Biden administration to want this to die on the vine, so to speak. And, you know, I think the courts go slow on these things to see if they'll work themselves out. There may be some wisdom in that.
Well, there's a case right now that's still going on. It's been going on for, I think, a couple years, and that is that effort to get tax returns from President Trump. We have a law that says if the Ways and Means or Finance Committees ask for these tax returns, they shall be produced. They asked for them under the Trump administration. They weren't produced. There was a case filed. Then when Biden administration came in, they said they would produce them. They changed the Office of Legal Counsel opinion to allow them to produce it. But now President Trump has filed a paper saying that he wants to prevent that from happening. So we've got that very live case going on. And then we have the January 6th cases, as you've mentioned already. So the question is, given McGahn, life after McGahn, how do you think those two kinds of disputes are going to be resolved? You can take one or the other. They're two very different ones, or complicated, but I'm interested in how you think this is now going to play out.
If you want me to go first or not, I mean, so the Trump tax returns case, yes, the Biden administration re-examined that, OLC wrote a very strong opinion making clear that there's a statute by God and it should be followed, and that it's not up to the executive branch to judge the motives of the legislators, just like the Supreme Court has made clear it's not up to them. So it's also not up to the executive branch. So it's a very, very strong opinion. Judge McFadden, who had been sitting on the case forever under the Biden administration, Judge McFadden now has moved with relative alacrity and set a quick briefing schedule. I'm well aware because we have a reply brief due in a very, very short time that is requiring a lot of people to stay up very late, including me. And we have a hearing set on November 8th. Now, obviously, we hope that Judge McFadden will rule in our favor and uphold. It's basically now largely Trump against the Biden administration and the House. We hope that Judge McFadden rules extremely quickly on that. And then, as I say, we're obviously up to the DC Circuit, whether it would issue a stay or whether the DC Circuit will say, briefs, let's have briefing done in 3 weeks, oral argument the next day, and we will rule within 2 weeks. DC Circuit could do that if it wanted to. And obviously we could get a very fast decision, but it really is up to the courts. The January 6th stuff, obviously, we'll have to see how that plays out. You know, we're, as you can imagine, I'm very much in the midst of all of this, and it's the Biden administration issued some very, very telling letters to, for instance, former Attorney General Rosen and Jeff Clark and others, saying that the Biden administration would not be asserting executive privilege for those officials to talk about January 6 events and the insurrection that Trump incited. So we'll see whether how that goes with other witnesses. As you well know, the January 6 committee has sent out a batch of subpoenas, and we'll see if those people do their duty as patriotic Americans and show up for depositions as they're supposed to and required by law to do.
Lisa, a few thoughts. First, it's a real tribute to the Levin Center that Doug actually has an hour that he is willing to give to you, given the sheer number of cases he's litigating at the moment. I represented Jeffrey Rosen in connection with his interview before the Senate and his cooperation with the Office of Inspector General of the Justice Department. And you're right, Doug, those were extraordinary letters from the Justice Department. I will note that before we proceeded with the Senate, we passed those letters on to former President Trump and gave them an opportunity to object to our cooperation, and they did not object. I don't know if that decision will come back to haunt them in some of these cases that are arising now that involve people that may have been participants in some of the same discussions or not. It'll be interesting to see, but they were given an opportunity to object.
That's fascinating. And, the letters that we've now referenced a couple of times made sort of an oblique reference to having themselves, the Biden Justice Department officials, made some consultation with former President Trump's attorneys and had to have made the determination not to assert executive privilege, notwithstanding Trump's request that they do so, or desire, maybe was the framing, that they do so. So it's interesting that that request then was not reiterated upon subsequent consultation. But it seems really clear that to me, look, I think folks who have a kind of congressional set of interests that are front of mind are sometimes skeptical of executive privilege. I come as a former executive branch lawyer to this as somebody who does believe in a strong executive privilege, but I think it's absolutely possible for the Biden administration to do what it did in those letters, which is to maintain a broad commitment to the principle of executive privilege and the importance of candid advice from advisors to presidents, and yet to concede, as you have to, that it's not an absolute privilege and that it is a context specific and dependent kind of analysis, and given the extraordinary circumstances of January 6th and the other things, and Reg alluded earlier to this, kind of sometimes there is either wrongdoing or outright potential sort of criminality at the heart of some of these disputes historically, and certainly wrongdoing potentially contained within some of the materials that are being sought by the January 6th committee, the request to NARA, to other, to executive branch agencies, and obviously these requests for testimony. Again, based on the general settled principle that serious allegations of misconduct or wrongdoing really erode or undermine the strength of an executive privilege assertion, and the extraordinary circumstances of an extraordinary need for information about January 6th. I think for all these reasons, the Biden administration can take, with respect to these January 6th requests, the same position that it took with respect to these Oversight Committee requests for testimony, which is that it can remain committed to a strong executive privilege and yet take the position that here the privilege is not appropriate and should not be asserted. And then I expect it will do that with these January 6 documents and sort of, and testimony. But of course, as to the individuals whose testimony is being requested or has been subpoenaed, we may well end up back in the courts. And I don't know that we know for sure that we will, but it seems quite likely. And it seems also as though it's going to be former President Trump who's going to be invoking the jurisdiction of the court. So I don't think are going to have these, cause of action for a congressional committee to enforce its own subpoena questions, but certainly these kind of core privilege questions that don't get answered at all in the McGahn litigation could well be presented. And I think there's a good chance will be presented in relatively short order, around January 6th.
Yeah, I agree with that. I think it's going to be very important to try to figure out the correct procedure here for the January 6th witnesses. Because we have two presidents asserting or potential claims, or two potential assertions of executive privilege. It's certainly many people believe that the former president has no authority, but that is certainly not a settled issue, and he's certainly not going to accept that based on what Congress says. So it seems to me that if we're talking about subpoenas to people like Meadows, who were top White House staffers in the Trump administration, I think that the procedure should be the same as what I was saying with respect to McGahn, which is he comes in with his personal counsel. His personal counsel can consult with the current White House and consult with anyone else, but it's Meadows' obligation to comply with the subpoena, because the subpoena is to him. And I think if I were the committee, I would allow the personal counsel to make objections, or if he wants to instruct the witness not to answer certain questions on the grounds that it's covered by executive privilege or potentially covered by executive privilege, then after the deposition is over, you give the current and former presidents the opportunity to formally assert the privilege with respect to those questions. And if they do, then you rule on them, because you have to have a process in place. But that's for Meadows or Scavino maybe, but for other people like Steve Bannon, he's the private citizen. He has no connection to the government at all with respect to his testimony. It's absurd to think anyone has any privilege that can be asserted here.
And just
Michael, I agree with
viewers
you
know
about
that we have in the chat that 4 minutes ago, the Washington Post broke a story that Steve Bannon has announced that he will refuse to comply with the January 6th subpoenas, just so everybody knows. That's the position that Steve Bannon is now taken.
Michael, I agree with you that the Bannon assertion is a head scratcher. I'm sure we'll learn of a new privilege soon. And Meadows is an interesting example because he's chief of staff to a president, almost the alter ego of the president, and you would think that the equities there would be quite strong, and the Biden administration might be hesitant to waive as to the president's closest advisor. For lawyers, there may be an additional wrinkle, right? Which is lawyers have obligations under the bar rules to preserve privileges, and if they're not clear who the privilege belongs to, they can really be in a tough spot in these kinds of circumstances. Because I agree that Nixon v. GSA, I don't think the law is fully settled yet on whether a former president controls or has very strong equities in privilege assertions.
I think Reg has raised an extremely important point about with regard to lawyers. I know there is a DC bar opinion that I think it was addressed to Jack Quinn, one of Clinton's White House counsel. If the lawyer is put in contempt of Congress, my memory is that the DC bar said the lawyer does not have to go into contempt in order to protect the president. And my memory is that Jack Quinn then said, "Oh, okay, I will respond to questions from Congress." So I don't know whether other bars have examined this, whether they would follow that. but the DC bar has made clear that the lawyers, responsibilities to the client and here obviously a former client continues when it's Congress putting that person in contempt.
And maybe can I just add one thing? So Reg mentioned Nixon versus GSA, and I think it's the only Supreme Court authority that talks about the relative roles of an incumbent and a former president with respect to privilege questions. And I mean, I think it's only about a paragraph, and I think you could read it in different ways. It feels to me best read to suggest, yes, a former president does have a cognizable interest, and the privilege survives the end of teaching abortion this week, the end of a presidency. Just finished common law, sorry. But that the incumbent president is, best positioned to assess the present and future needs of the executive branch to support the invocation of the privilege. Accordingly, it seems to me there's not really a dispute that it is the incumbent whose views control in the event of conflict between a former and an incumbent. So it matters a great deal what the Biden administration decides here. If we end up in litigation and you have the Biden administration saying there is no need to assert privilege here and it is only President Trump, and even, and that I think is an argument he can certainly make with respect to Meadows. I think it's very difficult to see how he makes it with respect to Bannon, Meadows and Scavino, and maybe there's another person as well. But that's the key precedent, and I think it can be read a number of ways. But I do think the two things it definitely says are Trump has some interests, and it's not a frivolous claim, but at the end of the day, those interests are not controlling.
I think it's very interesting that we went decades without any cases going to the courts on congressional oversight and enforcing subpoenas, and in the last 3 to 5 years, we have repeated numbers of cases. Mr. Bannon may be the next. Somebody who is not associated formally with the government, but is going to come up with some reason about why he's special and doesn't have to comply with congressional subpoena. And that may have to go to court. For Congress, it may be a long, drawn-out affair, but it may be a good thing because Congress may prevail. And that's what strikes me is that each of these cases are so specific. The January 6th thing, as I hear everybody saying, can a former president assert, can a current, executive privilege, but how does the facts that we're dealing with the insurrection affect all of that and possible misconduct? But I want to take one more minute to go back to the tax return case. And the reason why is it's a statutory case. So it's not just a pure Congress trying to enforce a subpoena, but actually trying to enforce a statute. And I think it raises a very fundamental question, which is, can Congress pass a law signed by the president at the time and force the executive branch to provide information? Now, you would think that would be resolved, but I don't know that it really has been. And it's interesting to me that it's not directly on the subpoena question, it's on a statutory question. And yet, if that goes through the process and Congress's ability is sustained to get that information, does that again add to sort of what's going on with all of these cases that says, yes, there's a right of Congress to exercise oversight? And I'm just trying to introduce this larger issue of, does Congress have a right to information? And should the courts be involved in the process of Congress getting information from the executive branch? And I want to just get your thoughts on that kind of larger question.
I'll jump right in, Elise, and my answer would be, and I'm hoping we'll have unanimity on this. Of course, Congress can demand information from the executive branch, and of course, it must be provided unless it fits within either a statutory a provision or a constitutionally based provision, privilege. If it's hard to see how a demand by the Congress for information pursuant to a statute, as you said, signed by the president, that would be protected by executive privilege for a tax return that goes. Some of those returns are long before Mr. Trump was president. And when it would be a very difficult executive privilege claim, because remember, The whole point of executive privilege is so that Congress can't interfere with the president's ability to carry out his or her job, right? That's why we have that privilege. Well, since we know that every elected president after Nixon discloses their tax returns except Trump, it's very hard for anybody to argue that, oh, presidents can't possibly do their job if their tax returns are disclosed, since apparently Reagan, Bush, Carter, Clinton, et cetera, they all could do it. So it would be an
how do you deal with
extremely
that
weak claim.
Mazur's argument that, well, Congress could be harassing the president and can harass the president in lots of different ways, and perhaps this is just harassment?
Well, the key,
I'm obviously, my heart is where yours is, but I
Yeah.
think it's a real argument that we have to think
Right.
about.
the key there is remember what the case is now, and that's the only case that will be adjudicated. We don't have any request for information of a president. It's an ex-president. And as we know, Nixon versus GSA says, and here, remember, we have the current president saying, yes, of course it has to be turned over. I don't get to look into whether there's harassment or not. It has to be turned over. So the current president is saying this has to be done. I claim that that is somehow some sort of violation of executive privilege or separation of powers, et cetera, by an ex-president doing something that's completely inconsistent with every other modern president. That's pretty darn close to frivolous in my mind.
Can I just ask a quick question? Has Trump even made any executive privilege arguments with respect to the taxes? I mean, the harassment claim, sure, and OLC bought it before this OLC withdrew that opinion. But I thought there was never even a claim that executive privilege was implicated.
I believe that is correct, Kate.
I don't think there's any executive privilege claim. He just thinks there's, it's a harassment. He is going to run again, possibly. So.
Right, and of course, his equities and interests are taken seriously in Mazars, and there's no privilege claim there either. So that's not to say that it's not a live dispute. But I would give the one-word answer to your question: can Congress do this? Yes, and should courts resolve these disputes? Also, yes. But I'm curious what others.
I think we've stumbled upon Steve Bannon's argument. He's going to argue there's no legitimate purpose, legislative purpose behind the work of the select committee, and you're going to see probably more.
He's going to want to apply that to that statute. That never.
If I were him, that's what I would. That's what I would do. I don't know how that works for the Trump tax case, but it is an interesting new front. So on the one hand, Congress may have won on the issue of subject matter jurisdiction, but now you're going to get more exacting scrutiny on the question of whether things fit within the proper purview of Congress when it's investigating things.
I'll just, for our viewers, what Congress has said in the past for a legislative purpose for getting the Trump tax returns is they want to look at the whole setup for how the IRS is supposed to audit presidential tax returns. In the past, it hasn't been a problem because everybody made them public. But here we have private ones. There are allegations of wrongdoing, of tax evasion, or other kinds of wrongdoing. And so how does the IRS audit it? Did they audit it? How did the president react? You can think of other reasons too, if you want to look at, well, we'll just leave it there. That's the claim for the legislative purpose in this case. But I think, Reg, you really raise an important issue is, can people start to take that legislative purpose and apply it to statutes that are simply, if we ask for it, you have to turn it over. And the president said that was okay. I mean, that whole thing came out of abuses by presidents and administrations on allowing tax return information to come out. So,
Lisa, I want to make a very quick point. It's remember that what Chairman Neal has explained, the chairman of the Ways and Means Committee, is that there's a whole aspect of this, for instance, that we need to look into presidential conflicts of interest, and that could be revealed by the tax return. So Chairman Neal has said that this is all tied together why there is an interest by the totally legitimate interest by the Ways and Means Committee into looking at that audit, a presidential audit program, and whether that program, remember, that program is only pursuant to an IRS manual. It's right now, it's not the law. We don't have any idea if IRS has even been doing it, how they've been doing it, et cetera. So big, an obvious legislative interest is, should this be made into a statute? And we need to find out how the program has worked, is working, et cetera, in order for Congress to be able, the House and then the Senate and President, to decide whether that would be good legislation or not.
And there's even a second argument. There's now efforts to create a statute to enforce the emoluments clause. And some people say we need to understand what President Trump was doing, because he's the first president that has raised emoluments concerns in many, many years. And that might have relevance to how that law is written as well.
Elise, as you know, that is a bill, and that is one of the issues before the DC Circuit in the Mazars case. Is specifically about one aspect of it is about emoluments, conflicts of interest. President Trump making, I think, the astonishing argument that all of those statutes about presidents having to disclose in conflicts of interest, et cetera, those are all unconstitutional. But,
right.
I never heard President Bush or President Obama saying that.
Michael, did you want to make a contribution?
Yeah, so on the issue of statutory authorization, there are, of course, been thousands of laws that Congress has passed over the years which require the executive branch to provide information in one way or the other, either in response to requests or in terms of continuing reports or whatever. Generally speaking, those don't have any judicial enforcement and have not been something that Congress has tried to say is judicially enforceable. There is a case, though, that involves the Section 2954 of Title V, which gives members of the Senate Homeland Security Committee, any five members of Senate Homeland Security, or any 7 members of House Oversight Committee, the authority to request information from any agency that is supposed to then give them the information. And there's a case on that. I'm not quite sure what the latest status is, but there was a DC Circuit panel decision that said that that is enforceable. They have standing to enforce that case, which I think arose out of the claim that went to court, arose out of the post office lease with the Trump organization, if I'm not mistaken. But if that case stands, then potentially you could have all kinds of suits by even the minority on these two committees to enforce requests to the executive agencies.
There's a lot going on. And I will tell you, there was another case that I was following for a while where the Commerce Department refused to provide a report that Congress, by statute and by committee report, had ordered them to produce. And we actually had 7 senators on a bipartisan basis file an amicus brief with the court to say Commerce Department was supposed to make that report public, not just give it to Congress, but to make it public, and ask the court to force the Commerce Department to do that. It was settled by the Commerce Department producing the report. So we didn't have any judicial ruling on it, but it's an issue that I've been following for a while, that you would think Congress could require the executive branch to produce certain kinds of information when they have a statute. It's often part of a statutory structure, that part of it is reporting to Congress. But I don't know in today's world whether a court would say, if that's court enforceable, if Congress asks for a report, they don't get it. Do we have standing? The McGahn case seems to say you would, and that there's jurisdiction to hear that dispute. But surprisingly, I don't know of a case that actually has resolved that on the circuit court level or much less in the Supreme Court. So that's future work for you, Doug. What I'd like to do is take sort of a 2-minute lightning round to go to each of you to give some final remarks about the significance of the McGahn case and how we should think about it going forward. And we've talked a whole range of issues here about ways that the case itself, but also its implications for the future. So I'd like to go into our lightning round. So Doug, why don't you start us off? And by the way, thank you so much for taking time out of your very busy schedule to help
I
all of us
apologize.
understand this case better.
I apologize. When I look away, it's either to keep my cat from walking across my keyboard or to look at emails about that are going on right now about some of the things we're talking about. So lightning round, that means I have to talk really, really fast, right? As I said, I think the big lesson from McGahn is, as we told the DC Circuit, litigation is not a good answer. And so, Judge Griffith thinking that the House or the Senate was going to jump and go to court as fast as they could, et cetera. No, that's not it. What's it is, again, and I know Reg says maybe we can't rely on this. It's adults in the room behaving in a constitutionally mature and appropriate way to negotiate with each other and figure out how to, make the government work between the executive branch and the legislative branch, like we have done for many, many, many decades successfully. We can't have administrations like the Trump administration taking those absolutist positions. And I think the rulings by the judges showed that. And again, look at the rulings by some 3 of the finest district judges in the United States, Judge Bates, the other Judge Brown, and Judge Brown now on the DC Circuit. They all totally rejected this absolutist view, et cetera. And so I think the lesson of McGahn is, yes, the House won some major victories that I hope will cause in the future presidents to say, look, let's do what my predecessors do. Let's negotiate with the House, the Senate, and figure out the best way that for the American people, and not have these kinds of things clogging up the courts, taking forever.
Reg, do you want to go next?
I don't think I could top what Doug had to say. I was sort of struck by the role of lawyers, that Don McGahn did go talk to Mueller. He gave the Trump administration the ability to pursue its arguments in court, but when the court kind of looked like it was going to come one way, and folks started to think about negotiating, he went in and complied again, which gives me some confidence in the strength of our system, that ultimately kind of the rule of law prevailed and lawyers did what they were supposed to do, when arguments had been exhausted, and that to me is sort of promising. I do think that this is significant, and that the balance of power between the executive branch and the Congress is shifting a bit in the favor of Congress. But that's a seesaw, and I suspect it will continue to move back and forth over time. And I just think it'll be fascinating to watch what happens if the House does flip and we're back in divided government. Will the position of the Biden administration about executive privilege flip, or even if there is a change in administration and Donald Trump wins in a few years, will he come in on day one, say nothing that happened during the Biden administration is privileged? And if so, will we all adhere to the view that the privilege belongs to the current president? Or will we revisit those issues? I think these are very hard issues, require an awful lot of thought, but ultimately very confident in the rule of law and its likelihood of prevailing.
Kate, do you want to go next?
Sure, maybe just a couple of things. I do think it's right that when the courts have actually reached the kind of merits of these disputes, they have favored Congress, although I think we all take a slightly different view of exactly what the best sort of nuanced reading of these different both lower court and Supreme Court rulings on these, oversight disputes really is. I think it's right that Congress comes out looking, comes out in a good position vis-a-vis the executive branch, but the timeline of the litigation has meant that as to the particular goals of the committees at issue, it's the wins seem to me fairly ephemeral. The law that gets made is of course really important. So I guess, one, that sort of figuring out a way to expedite these timelines seems critical to me. But two, it seems to me to matter a lot. And I presume that Doug and his team are thinking about this, but that if, given how few, merits resolutions of these disputes the courts actually issue, it matters a lot, right? What the particular facts on the ground of the disputes they're going to get to the courts are. And so thinking about whether Bannon or a Meadows, and whether it's a committee seeking to enforce or a former President Trump seeking to assert executive privilege, the posture in which these cases arrive at the courts, all these things seem to matter to me a great deal, because again, we have this like single digit number of cases that form the backdrop against which these disputes play out. Hopefully, in the best scenario, as Doug describes, adults make compromises and get to mutually tolerable resolutions in all these disputes. But again, the court cases loom over all of it. And so I think that a big loss for Congress in one of these cases could set back, congressional sort of prerogatives in this area a great deal, and a win could make a really big difference too if you're worried about Congress not having sufficient power in some of these disputes with the executive branch. So I think it matters a lot which of these cases gets litigated, how it gets litigated, and I do think that more judicial authority would probably be really useful in structuring these debates, in particular if there were more that actually reached the merits. And so it seems to me that case selection is really important here. And then to January 6th, maybe I'll say just one more thing, which is here it seems to me it's as important that the information actually emerge in a meaningful way as it is that Congress notch a victory as against the executive branch. Here, the actual record building task of the January 6th Commission seems of paramount importance. And so I hope both that the sort of Congress is able in a long-term way to get favorable authority if this does end up getting litigated, but also that it happens quickly enough that there's actually an opportunity for that material to be incorporated into the final product that the committee produces.
And Michael, you get the final word.
Okay, so I will finish on a note of pessimism, which is my want. I think to me, the big lesson of McGahn, or big takeaway, is how wide we have opened the Overton window on these kinds of claims. Because remember that Don McGahn was a counsel of the president. He talked to the special counsel and gave special counsel information, which the special counsel said conceivably amounted to obstruction of justice. But the special counsel said there's nothing we can really do about it because the president can't be prosecuted, and therefore it's up to Congress. Congress then went out and issued a subpoena to McGahn, who is now a private citizen, not even a government employee anymore, right? And in both its oversight and its impeachment capacities, wanted McGahn to come in and answer questions. And he said, no, I don't have to answer any question. Or really, the Justice Department said no, and McGahn said, I have to do whatever the Justice Department says. So he did not even show up. So the position of the Justice Department was, if you're a high-ranking government, or you're a high-ranking White House aide, even if you witness the president personally committing, or you personally witness the president committing treason or bribery, tough. Congress can't ask you to testify if the president doesn't want you to. That is not even what, when Bill Rehnquist kind of dreamed up the idea of absolute immunity in a very casual memorandum he wrote to Ehrlichman back in 1971 or so, I don't think he would have dreamed in a million years that it would be used for that kind of purpose. And yet we somehow drifted into a position where that is, a plausible position, which needs to be, I think that that window needs to be dramatically closed, if not entirely shut. So that is my pessimistic take on the matter.
Well, I want to thank all four of you for these very thoughtful and important comments on the McGahn case. From the perspective of the Levin Center, you can't have good government without good oversight. It just won't happen. The executive branch, as our framers knew, you need to have some oversight going on, and you can't have good oversight by Congress of the executive branch without the ability to get good information. I think for me, the message of McGahn is that norms are not always enough to get that information. You don't always have the adults in the room. And so sometimes you do need to go to courts. So from the perspective of the Levin Center, we support the ability of courts to resolve some of these disputes. I also think there was a question in the chat about whether Senator Levin, what were his views in terms of changing the statutes. His point of view was that Congress has a lot of different ways to get to court, 3, 4, 5, 6 different ways, and the more the merrier. So I think he would have supported legislation to strengthen the hand of Congress to get to court, to have a clear, viable cause of action. Whether we can get that is something else, but we should get it. And I think for the health of the country, we want to have a powerful Congress that at least can go to court and between the 3 branches be able to get information, as Michael said, that about some very serious matters. So I want to thank you again for your fantastic contribution to this panel, for all 4 of you taking the time from your very busy schedules to educate all of us and the oversight community that's been watching this panel. So thanks again. And I'm also going to put into the chat, we do have an emerging case law website where we've collected all of the key pleadings. For example, in the McGahn case, we have about a dozen other cases as well. So you don't have to look all over the web. You don't have to have money for Pacer. You can just go to our website. And I invite you to do that, and we'll continue to track these cases because they are important. Thank you so much.
Thanks very much.